Hello, my students of 5th semester. Today we are going to study uh, Criminal Procedure Code. The topic is warrant case and summons case. Now, in summons case, summons means summoning someone through a document. That is a court's document through which we can call someone. That is summon. Now, if a complaint is filed before a magistrate and the person against whom the allegation is made is summoned to court and the case starts, that is generally called summons case. Actually, nowhere in the Criminal Procedure Code what is summons case is clearly described. What is described that in section 2 W, it says that summons case means in the case relating to an offence not being a warrant case. তার মানে যে কেসটা ওয়ারেন্ট কেস নয়, যেটা কোনো অফেন্সের সাথে রিলেটেড, that case is summons case. Now question is, what is then warrant case? Chapter 19 of the Code of Criminal Procedure deals with warrant case. Now, warrant case means according to section 210 2 Roman X. Warrant case means a case relating to an offence punishable with death, imprisonment for life or imprisonment for term exceeding 2 years. তার মানে সেই অফেন্সগুলোর কেসই ওয়ারেন্ট কেস যেগুলোতে শাস্তি, ম্যাক্সিমাম শাস্তি হচ্ছে ডেথ পানিশমেন্ট অর লাইফ ইমপ্রিজনমেন্ট অথবা 2 বছরের ইমপ্রিজনমেন্ট। আর এই কেসগুলো বাদ দিয়ে বাকি কেসগুলো হচ্ছে সামন্স কেস। তার মানে ইট ইজ ভেরি ক্লিয়ার দ্যাট সামন্স কেস আর লাইটার পেটি কেস দ্যান দ্য ওয়ারেন্ট কেসেস। Now, there are two or three questions regarding this topic. One is describe summons case. What do you understand by summons case? What is warrant case, and what are the difference between the two? So, you cannot say only the definition. You have to describe the case. So you have to go in depth. In depth, what you can say that the object of the provision of warrant case is that it is more harsh. You cannot avoid a detailed trial, but in summons case one can avoid a detailed trial because the offences are less serious. In warrant case, section 240 provides that first step is framing charge. When there is a warrant case is filed, then it is the duty of the court to frame a charge. If court is satisfied from the police report or from the investigation that a substantial offence has been committed. Now, next step is section 242, that is evidence for prosecution, and then section evidence for defense. Evidence for prosecution, that means prosecution will be asked to submit their evidences, court will call for the witnesses as per wish of the prosecution, and magistrate on application of the prosecution shall issue summons for the witnesses. Witnesses will be examined. This is evidence for the prosecution. Then evidence for the defense, that is the accused person shall have been given a chance of hearing. He shall be allowed to produce his own evidences, own witnesses. Court will call for witnesses as per requirement of the accused person. Court will hear evidence of the prosecution and evidence of the accused. Then procedure where accused is not discharged. Now, after framing of charge, court may discharge the accused if court finds that as per prosecution there is no point, there is no case against the accused. Whatever charge there is against the accused is completely are completely baseless, so they can discharge. But after framing charge, this discharge may be happen before framing charge, but after framing charge there are two options, either conviction or acquittal. If from the evidences given by the prosecution and the accused person, that is defense, court finds that there is ample reason to believe that the accused person has committed the crime, that court will find him guilty and may pronounce judgment for punishment. And if it finds not guilty, then he will acquit the criminal. So after evidence of prosecution and after evidence of accused, that is defense, there are two options before the court, either acquittal or punish him. And in case of summons case, the person has right to plead guilty also. He can plead guilty. That means court then shall have option either to find him guilty on the basis of his aversions. সে যা বলছে, সে নিজেকে গিলটি প্লিড করছে যে ইয়েস মাই লর্ড, আই হ্যাভ কমিটেড দ্য ক্রাইম অ্যান্ড সো প্লিজ ফরগিভ মি। দিস ইজ গিলটি প্লিড। Court may find him guilty or not guilty on the basis of his guilty plea, or court may not rely on his guilty plea and may go for similar, that is evidence of the prosecution, evidence of the accused person, and then may acquit him or may punish him. And today we are going to study another topic, that is from Code of Civil Procedure, that is suit of civil nature. This is the primary question of CPC, Code of Civil Procedure, that is what is suit of civil nature. A suit of civil nature is the principal question in the suit relates to determination of civil right. I mean, a suit where civil right is in question, that suit is called suit of civil nature. Now the principal question relating to caste, relating to religion, religious right, relating to ceremonies cannot be the part of suit of civil nature. Where civil right are disputed, that suit is called suit of civil nature. But if subject matter of suit is relating to question of ceremony, question of religious right, question of caste, then that is not a suit of civil nature. It is stated. Section 9 expansion 1 provides that if there is a question that whether a suit is suit of civil nature or not, and it is found that there are some subsidiary questions which are relating to caste, religious right or ceremonies, but the principal question is of civil nature, that is principal question is relating to civil right. Let me make it clear once more. The basic principal question that is involved in a suit, suppose, is of civil nature, that is regarding civil right of an office, civil right of an property, that is civil nature. But there are some subsidiary questions, কিছু আনুষঙ্গিক question আছে, which are relating to religious right, relating to religious ceremony, relating to caste. And if we cannot decide these subsidiary questions, we cannot decide the principal question. Then civil code is allowed to decide the subsidiary questions and then to decide the principal question, and these suits shall be treated as suit of civil nature. Expansion 2 once again says that suppose there is some whether there is some monetary benefit is related, monetary benefit is involved with such office, right to office or right to property, suit of civil nature, question of civil right, whether there is some monetary question or financial question is involved or not, that is immaterial. That means expansion 1 overrides everything, whether there is any monetary question, financial question or not. That if there are subsidiary questions of religious right, subsidiary question regarding ceremonies of caste, regarding religious ceremony, etc., then if the principal question is of civil nature, then the suit shall be treated as suit of civil nature. And civil court's jurisdiction to grant such relief for the simple reason that proceeding before the magistrate was not a civil proceeding but proceeding of a criminal nature. Suppose a suit is filed before a civil court, which is liable to be filed before, which is actually required to be filed before a magistrate, that is, the suit is purely of criminal nature, then that civil court has no right to give him relief. But when there is a statutory enactment, only creates rights and liabilities, but there is no remedial measure is provided in that statute. Suppose there is a statutory right but no remedial measure is provided in the statute, then a civil court may entertain such suit for the restoration and for the reinforcement of those rights. Here comes the principle ubi jus remedium, that is, no right can exist without right of remedy. Thank you.